Hi, it's Mike Del Signori. Today, I want to talk about the civil case of Karen Reed. I was on a show with Linda Baden where we talked about this on Justice Served. So I want to go over it with everyone today, what the motion to dismiss was about and what the issues are in the civil case. So they're at the discovery stage. It's a very, very early in the process in the civil case. Karen Reed's lawyers proposed adding 10 additional third-party defendants. The judge seemed hesitant to do that, unsure of the procedure, but he said, you know what, there's nothing in front of me, file the motion, I'll address it at that time. The judge in charge of the civil case, Judge O'Shea, judge I've been in front of many times over the years, probably judges get the reputation of being down the middle. He's earned it. He's probably one of the most fair judges that could be selected for this case. So I think he's a great choice. He knows the law, studies the law. He always has the evidence book right with him right on the bench. So the motion to dismiss surrounds the intentional infliction of emotional distress claims. So the argument is that there can't be emotional distress because the alleged victims, the plaintiffs, weren't at the scene. So to prove an negligent infliction of emotional distress, you need to prove you suffered emotional distress and you had physical symptoms of the emotional distress, and it was foreseeable that you would suffer emotional distress as a result of the negligence of the defendant. So these are interesting cases. So the type of case that qualifies for negligent infliction of emotional distress is somebody's seriously injured in an accident. The mom rushes to the scene. That's compensable. The mom could also rush to the hospital. However, if you learn about an injury in another state, you're told by a third party, even if it's a death or serious injury, that's not compensable because it's not foreseeable that you would suffer emotional distress. So there's a concept of foreseeability. Some states use a term called the zone of danger. We don't, but it's similar. Basically, you have to have a close family relationship and it's foreseeable that you'd suffer emotional distress. So at the motion to dismiss stage in these cases, the judge basically is just deciding, are there any facts on which the plaintiffs can get relief? So if there's any facts, the judge assumes they're all true, the motion to dismiss should be denied. So we'll probably get a ruling shortly on those motions. The next stage would be summary judgment. That's a little more rigorous review, but these claims of the plaintiff probably will go to a jury, and we'll find out soon whether the third-party defendants will be added. My name is Mike Del Signori, 781-686-5922.